This election season, there's more on the line for Donald Trump than securing just a second term in the White House. A win at the presidency could be a deciding factor in Trump's various legal troubles, and this includes his classified documents case and his 2 election interference cases. Now, this is on top of Trump's 34 convicted felony counts in his hush money case, with the sentencing date scheduled at the end of November.
Ooh, Chief Legal Analyst Khalif Rhodes joins us now to break this all down. And if he wins, does it all go away?
That whoo right there really got me, because that's how you feel when you're looking at these, right? This is like those books when you read when you were a kid, to choose your own adventure. This is actually an opportunity for the president to choose his own adventure. If he's elected, some of these could potentially go away. If he is not elected, some of them could still potentially go away, just in another capacity. So I got them broken down in a couple boxes, right? The hush money case in New York, the documents cases, the special counsel cases, and then the Fulton County, Georgia case. Let's start with Fulton County. I think that's the messiest of all of them. I mean, there are a number of charges. 19 plus people were charged. There were a number of charges that have been dismissed, but that is not really what's making this messy and murky. It's the DA's office making sure that they can even try this case. Fonnie Willis and her team maybe having to step aside. So that case, I think, is the strongest, because he doesn't have the power to make that disappear as the president, for sure, and the governor can't pardon him as well. And so that case can stand even if he is elected or not. But I think if they can get out of the mud that has been this prosecution so far, it will have the legs even if he is elected or not. Now, if you're talking about the Jack Smith special counsel cases, Florida judge dismissed the cases back in July, but they're appealing that, Jack Smith and his team. D.C., they're chucking right along, because now they have to determine what are presidential actions and what are not. I think if he's elected, you would say in a normal world, the Department of Justice can continue to move forward and prosecute him if he wants to. It would be his Department of Justice head that he would pick. But I think that if they're doing what they're supposed to do and the facts of the case point you to there, you have a legal obligation to continue to prosecute, even if your boss is telling you not to, because we do have this thing called the separation of powers. Then the last one with the New York hush money, he's already convicted. This is just when will he be sentenced. I mean, there's nothing stopping this from happening. I can't see any case law that says, you know what, we have a convicted person that was convicted by a jury of his peers. Yes, they can appeal, but they'd have to come up with some new facts, something that was done improperly on the trial level. And I don't see anything that could possibly show that that didn't happen right there. So all I can tell you is, even if he's sentenced, he may be sentenced after he comes out of office 2029, or he may be sentenced before and not serve time until after. But there's nothing stopping that case from him being sentenced on November 26th after the election.
So we could see potentially a president-elect be sentenced for a crime. I mean, that's, again, everything is historic when we're talking about these things. When we talk about the civil cases there, the E. Jean Carroll, the exonerated 5 lawsuit that we saw come out there, what does that do when you're pursuing a civil case against potentially a president-elect?
I mean, it makes it harder, obviously, to make sure you can get him there in court. But the problem is, or the good thing is, he doesn't have to be there. In these criminal matters, he has to physically be in the courtroom. And as his attorney said, Sato, in the Georgia cases, he said, I can't see a way that you get over the supremacy clause forcing the president to be here when he has the obligation to be running the country. Part of his argument I buy. The other part, I think there is no precedent for it, because we haven't been here. Regarding the civil process, look, you got to be in court. You have to sue people, and their attorneys will represent them. And so he can have 4, 5, 6 different civil cases happening at the same time and not have to be there and still run the country. Now, is that a good look on the world stage? Probably not, to have your actually most highest ranking person in the country being sued. But people are sued all the time. We're a litigious society. And so I don't think that one is as hard as trying to make him sit still in court in Georgia during a RICO case as the president of the United States. That is going to be the hurdle. That would be something that is just really weird to kind of fathom. But we're here now. Before, these would have been things that were like, long ball stretches, imagination, if I'm trying to think of some type of science fiction. But this is our new reality, and this is what we have to deal with. But he has a lot to control here.
Real quick, let's go back to that federal case. He goes into office, he picks all of his people, so that could just make everything go away?
It could, but I mean, again, we hear this politicizing of the weaponizing of the Department of Justice, right? That this is his Supreme Court. These are his. They're not. There is a clear separation of power. We have our Supreme Court, which is in the judicial branch. We have the executive. We have the legislative. So even though he picks the head, they still independently run those agencies. And so as a prosecutor, if the facts point to this person, even if that person is your boss, in our profession, you have a higher burden to follow the law, not what your boss is telling you to do.